astonishing manoeuvre to have presented a case where there's a denial of liability to one where there's been an acceptance of liability on the courtroom doorstep, as it were. But the other aspect, which is more concerning, is that the manner in which that was done has really suggested that there's no accountability and transparency or scrutiny in relation to why police have done what they've done in all these instances of strip searches. It was a very bizarre and confusing manoeuvre, brought about at the very last minute in circumstances where the state, with all of its might and resources, have obviously not properly prepared, countenanced the possibility that what they had done was thoroughly legal.
So criminal and civil solicitors are renowned for civil actions against law enforcement. What systematic legal failings do you believe this case exposes about police search powers in New South Wales?
Two fundamental things emerge from the manner in which this case was run and the manner in which the case appears to have been defended. The first is that the police do not have a clear idea of how their powers are being exercised, how their functions as police officers are being utilised in the field. And secondly, they are so blind to the manner in which the police, it would appear, are operating on a day-to-day basis and using what are extremely invasive and coercive measures against, in many instances, young people, vulnerable people also, in a manner which appears to be entirely ad hoc and capricious and arbitrary.
From a civil liberties standpoint, how dangerous is the use of drug detection dogs with a known high error rate as a gateway to intrusive procedures like strip searches?
It's a grossly disproportionate policing approach. The difficulty is that dogs are not reliable indicators of drug detection. As you say, less than 50%. In less than 50% of instances, a dog's successful. So the possibility that a person is carrying drugs cannot be indicated by a drug detection dog, even the best of them. So when you're looking at the use of this sort of power, this sort of invasive, complete deprivation of privacy involved in a strip search, that it's used upon and the circumstances in which it's used, some of the very harrowing circumstances which have been described and which we've litigated, where people are told to bend and cough and squat, manoeuvre themselves into positions of extreme depravity and in very humiliating circumstances. The actual public policy that enables that to happen almost arbitrarily is completely disproportionate to the damage that it can do.
So what role do you think class actions like this play in both providing justice, applying pressure for institutional reform within the police forces?
Look, I must say, when I first heard of this action, and of course we prosecute illegal strip search cases all the time against police, not only police but other institutions including corrective services not only in this state but around the country. And I was surprised that there was a class action of the type that was dealt with in the Supreme Court recently, is now pending judgment, because it generally requires an understanding of what each individual police officer thought in terms of the suspicion that was raised on each individual search. This was always apparent to me as a possibility, was that they're not keeping records, and that emerged in this trial, that police are not keeping records of the searches that they're doing, particularly in these festival type environments where they are just doing strips after strip search. Records are not being kept. They are doing it with almost blatant disregard to what their responsibilities and powers actually are. Therefore, condemning it illegal, but also it shows how systemic, this case has shown how systemic this problem really is, particularly for youth in our country.
If your firm were acting in this case, would you have approached any aspects differently, especially in terms of strategy or the pursuit of damages?
We don't do class actions, and it's not because this class action hasn't been a helpful or useful one, hopefully a successful one. I'm impressed with how it was run. From what I've seen and read, it appears to have been prosecuted in a very effective manner. In fact, so much so that it seems to me that the king piece was thrown down before the game was over. So I think it's thrown a light on some very appalling police practices and a real lack of training and a systemic indication of the real failures in the application of law, perhaps the ambiguity in the law, and obviously the ability of police officers to understand what the law is before applying it to people.
What does this case reveal about the psychological impact of unlawful searches, not just in the moment, but through the drawn-out litigation process?
As I understand this case, there was fierce resistance in the defence, and the manner in which a defendant defends cases such as this, which connect to a person's individual rights and civil liberties, can be part and parcel of the overall damages award. And I think that's what has been litigated by the plaintiffs in this matter, is that the manner in which the defendants have approached the litigation and approached the defence might well give rise to a form of aggravated damages or even exemplary damages for the manner in which the litigation was fought. And that is open, long established as a form of damages payable in the right circumstances. So it seems to me that, as indicated, some of the real problems in prosecuting claims against the state, you're fighting usually as an individual with very limited or no resources against a institution, the state indeed, with all of the resources in the world. So it is a David versus Goliath situation. So it really draws into sharp focus the sort of work that we do day in and day out in prosecuting claims against policing authorities, and the difficulty in doing that, particularly where there were such disparities in resources available on each side of the bar table.
Some people argue that strip searches at festivals are justified by the need to prevent drug overdoses. How do you respond to that rationale?
There's simply no evidence that the use of drug detection dogs or increases strip searches is reducing the number of overdoses anywhere at all. In fact, there is empirical evidence that suggests, certainly anecdotal evidence that would suggest, that people are taking more risks by panic ingestion of large quantities of drugs that they may not have intended to take because of the fear of a possible search. Harm minimisation approaches, if that's what is wanted to be gained in the way in which we deal with drugs, and I think it's obviously the most laudable approach, would dictate that we have testing facilities, we have medical facilities available, broader education campaigns perhaps more appropriate. But the argument that strip searches, or indeed any sort of search, or increasing police powers in relation to drug misuse, drug possession, is going to help reduce overdoses is a complete fallacy.
What reforms would you like to see implemented immediately in the wake of this case?
Well, I'm very interested to see what the Supreme Court has to say about this case, and no doubt if there are obvious systemic problems that have been identified in this action, the Supreme Court will make point of them. But but it seems to me that we need to urgently investigate how police are using the powers, how they've been trained to use the powers of searching and strip searching, and reviewing whether these powers are useful, helpful, or in fact damaging and an overreach.